Registrar, Trade Union. My lord, parties are absent.
Parties absent. Appearances. Appearances on this matter, please.
May the court be pleased.
Yes, please.
AB Alpha.
AB.
Alpha.
Yes.
With the brief of MO Ogedengwe.
MO Ogedengwe.
Yes, my lord.
Your representation is for the
claimant.
No representation for the defendants?
Defense counsel. No, my lord.
Yes. Claimant counsel.
My lord, the case is coming up for the first time. Slated for.
Yeah. Case is for mention.
Yes, my lord.
Yes, the defendants have been served.
Yes, they've been served the processes, but they are yet to respond to the process.
Okay, so we'll have to slate it again for mention. By the rules of this court, you will have to bring a motion to set it down for hearing before we can proceed.
Okay, my lord. You will have to bring.
The 28th of January for mention, for further mention, 28th January. By then you'll have brought in your motion. Is it convenient? I can't hear you.
It's okay, my lord.
Okay, for further mention.
I agree to my lord.
Court case is adjourned to the 28th of January 2026 for further mention. Hearing notice shall be issued and served on the defendants.
As the court pleases.
So do we have the counsel for the next case? That's
yes,
11/2024.
Yes, my lord, we are here.
Okay. Okay. Yes, you can. You can call the matter, please. Thank you.
Case number 2, NICN KJ 2024 between Barrister Clay Ojumu and Professor Akubo Aleo and 2 others. Parties absent, my lord.
Parties absent. Appearances, please.
May the court be pleased.
Yes.
AB Alpha for the claimant.
Yes.
May your noble lordship be pleased. I am NO for the defendants.
I didn't get the last name. NHF.
Yes, my lord.
Ruling.
As court pleases.
On the 29th of April, 2025, this Honorable Court granted leave to the claimant to amend his complaint and other originating processes. The instant motion on notice was filed by the defendant on the 19th of June 2025, seeking the leave of this court to amend their statement of defense and witness statement on oath of one Dr. Emmanuel Adejo. I have given due consideration to the said application and the facts deposed in the affidavit filed to support the same. The proposed amended processes, the totality of the written and oral arguments canvassed by the defendant's counsel in support thereof. In the same vein, I had also carefully considered the oral arguments canvassed by the claimant's counsel in opposing the application. According to facts deposed in the affidavit filed to support this application, particularly paragraph 3D and E thereof, the amendment is sought to make available facts that will assist the court to determine the real question or issues between the parties. In opposition, the claimant counsel, in his oral submission, cited the provision of Section 83, sub 3 of the Evidence Act 2011 and the case of NSE versus Kachi 2017, 7 Nigeria Weekly Law Report, Part 1564 at 278, and argued that the proposed amendment contained a counterclaim which are based on facts that occurred after the instant case was filed in April 2024. He further argued that the amendment sought by the defendant will cause injustice to the claimant. The question that the court must now determine is whether, on the basis of the totality of the circumstances of the case, it is proper to grant the amendment sought by the defendant. As it is well known, the rules for amendment of pleadings are very flexible and depend on the discretion of the court. An application for amendment can be made by a party at any stage of proceedings before judgment, and a court in determining whether or not to exercise its discretion in favor of granting the application must be guided by laid down principles enunciated and handed down from time immemorial by judicial precedents. See the cases of Brow Shipping Nigeria Limited versus Ometraco International Limited, and the case of Alawiye versus Ogunsoya cited by the defendant's counsel. As correctly submitted by the defendant's counsel, the overriding ground for granting an application for amendment is basically to ensure that the real issues in controversy between the parties are brought to the attention of the court for proper adjudication. It is also to ensure that justice is done to the parties to the disputes. In the case of MT Maman versus AA Salauddin, 2005, 18 Nigeria Weekly Law Report, Part 958 at page 478, it was held by the Supreme Court, among others, that, I quote, the general principle of law on amendment of pleadings as laid down by courts is that the amendment is generally granted at the discretion of the court, provided that such amendment would not establish any prejudice, unnecessary expense, surprise, irreparable inconvenience to a respondent, or show any lack of good faith on the part of the applicant, end of quote. Also in Alston Essay versus Chief Saraki, 2000, 14 Nigeria Weekly Law Report, Part 687, page 451, the Supreme Court held, among others, that, I quote, the basic principle of leave to amend is for the purpose of determining the real issue or issues in controversy between parties. The courts have always followed the established principle that the fundamental object of adjudication is to decide the right of the parties and not to oppose sanctions merely for mistakes they make in the conduct of their cases by deciding otherwise than in accordance with their rights, end of quote. I have proceeded to examine the substance of the amendment sought by the defendant's applicants as set out in the amended statement of defense and amended witness statement on oath. They contain facts which, according to the applicant, will be necessary to determine the real question or issue between the parties. The amendment also contains a counterclaim. It has been settled by several decided cases that a counterclaim is to all intents and purposes a separate action, although the defendant, for conveniences and speed, usually joins it with his defense. See the cases of Arije versus Arije and Laduni versus another versus Wema Bank, citation supplied. The contention of the claimant's counsel is that the counterclaim contains facts that occurred after the suit was filed in April 2024. In the averment at paragraph 9 of the proposed amended statement of defense, it was alleged that payments were made into the claimant's account in settlement of all his entitlements, which payments started on the 19th of September 2023 till the 9th of July 2024. The defendants further alleged that the claimant has been overpaid and for which sum is being claimed. The defendant's counsel's reply is that the facts had been in existence before the suit was filed and the said payment did not just occur, but had been ongoing before the case was instituted. In the instance case, the question is that what prejudices, injury, or injustice will the claimant suffer if this application is granted? It is elementary to state that by the provisions of Order 26, Rules 3, 1, and Sub 1 and 3 of the rules of this court, allows a party to amend any defects or error in any process, and all necessary amendments shall be made for the purpose of determining the real issues between the parties. It is my view that parties should be allowed to bring to the fore every available facts that they consider germane to a just determination of a suit, so long as the rights of the adverse party is not infringed, and so long as it is not shown that the amendment is sought to overreach the adverse party. I therefore totally disagree with the argument of the claimant's counsel that the proposed amendment is based on facts which existed after the case was filed. In my view, the focal purpose of the present application is to afford the defendants the opportunity to put forward all the facts available to them and to assist the courts in determining the real issues in controversy between the parties in the suit. It is my further view that more injustice will be done to the defendants if this application is refused, as their right to fair hearing would not have been seen to have been protected. On the other hand, whatever inconvenience is caused to the claimant by this application could always be redressed by filing a consequential amendment or compensated in costs. Ultimately, the focus of the court is to ensure that it is seen that justice is even handedly served to all the parties at the end of the day. In totality, I find merits in this application. Same shall be and is hereby accordingly granted. Leave is hereby granted to the defendants to amend the statement of defense and witness statement on oath. It is further ordered that the amended processes bearing the endorsements prescribed by provision of the 26, Rule 8 of the rules of this court, together with all accompanying processes, shall be filed and served on the claimant within 7 days. Parties shall bear their respective costs.
We are most grateful for the well-considered ruling, my lord.
We are most grateful, my lord.
So we pick a date for hearing.
Yes, my lord.
Our court pleases. Thursday.
Tuesday, the 3rd of March.
It's convenient, my lord.
It's convenient, my lord.
Court cases adjourned to the 3rd of March 2026 for hearing.
Our court pleases.
Yes, can we have the next case, please?
Case number 3. CN.
Just a minute, please. Parties absent, appearances, please. This. Appearances.
Except he has joined.
Counsel, can you check whether you are muted if you are in this matter? Registrar, which was the first case that we just dealt with? Is it Barrister Cletus?
Yes, my lord.
So this other one now is R.U. Eluko?
Yes.
Okay. Parties absent? No legal representation for parties. Can you call the case for judgment? Maybe they will wake up before we conclude the judgment. Are parties for the judgments available?
Yes.
Okay, call the judgment, please.
Case number NIC KJ 18/2022 between Edgar Steven and Police three others. Claimant is present.
Claimants present. Defendants absent. Appearances,
Yes.
please. A.O. Onoja for the claimant. Yes.
Before I strike to this honorable court, my name is Oyetunji Ruokai, Deputy Director, Ministry of Justice. My colleague,
DD litigation.
DDCL, litigation.
Okay, yes.
With Victor Ayegba. Ayegba spells A-Y-E.
Okay.
Senior legal officer for the defendants.
Judgment. The claimant initiated this suit on the 9th of September 2022 by originating motion under the Fundamental Rights Enforcement Procedure Rules. However, by the ruling of the court made on the 25th of May 2023, parties were ordered to convert the originating motion to complaint. Pursuant to the said order, the claimants filed a complaint and statement of facts on the 31st of May 2023, wherein it claims against the defendants the following reliefs. I'm sure you would understand why I cannot read the reliefs. We have 13 of the release as stated on the face of the judgment. So that's to move forward. I will not be able to read the release, but they are contained on the face of the judgment. A summary of the claimant's case, as gleaned from the statement of facts, is that he was employed as assistant lecturer in the Department of Architectural Technology of the third defendant, and he has not breached any of the conditions of his appointment or the scheme of service of staff of the third and the fourth defendants. The claimant alleged that in violation of his fundamental rights, the defendant illegally, wrongfully, and without just cause refused to pay his monthly salaries and allowances from April 2017 till date. His grievance is further that the arbitrary stoppage of his salary or purported termination or dismissal of his appointment was contrary to the procedure in the conditions and scheme of service and statutory laws. The defendants joined issues with the claimant by their joint statement of defense filed on the 7th of June 2023. The defendants admitted that the claimant was offered appointment as assistant lecturer by the third defendant on the 4th of November 2015, but contend that the claimant's appointment was irregular and illegal. According to the defendants, the claimant did not comply with the required conditions for his appointment. Essentially, the defendant's defense is that the claimant was amongst other members of staff whose appointment was without due process, that at the time they were offered appointments, no budgetary provision was made for the appointment, that it was difficult for the third and fourth defendants to continue the payment of salaries and allowances of the claimants, which resulted in the stoppage of his salary and the termination of his appointment. The documents tendered by the claimant to establish his case are: 1, letter of offer of appointments as Exhibit A; 2, letter of assumption of office as Exhibit A1; 3, letter of confirmation of appointment as Exhibit A2; 4, letter of implementation of CAPAS or Contendees 15 in Polytechnics as Exhibit A3; 5, internal staff verification form as Exhibit A4; 6, revised condition of service and scheme of revised condition and scheme of service for staff of the Polytechnic 2017 as Exhibit A5. 7, letter forwarding the list of Kogi State Polytechnics 2015 academic staff appointments as Exhibit A6. 8, 2015/2016 list of Kogi State Polytechnic academic staff appointments as Exhibit A6B. 9, photocopy of memo written by the Attorney General Kogi State to the Secretary to the State Government as Exhibit A7. 8, claimant's educational certificates or credentials as Exhibit A8. The defendants averred that the claimants and those affected by the stoppage of their salary and termination of their appointment were informed of the irregular and illegal appointment and contend that the claimant is no longer in the employment of the third defendant, as he has stopped work since 2017. The defendants deny violating The claimant's fundamental right to his means of livelihood as his employment with the third defendant is not a fundamental right. The defendant urged the court to dismiss the claimant's claims as being incompetent, inconsistent, lack of reasonable course of action, frivolous and abuse of court process, and lacking in merit. The defendant did not tender any documents in evidence. In his reply to the joint statement of defense filed on the 26th of June 2023, the claimant averred that his appointment was based on his educational qualification, and upon assumption of office, the original certificates of his educational qualifications, NYSC discharge certificates, were cited, while the photocopies were received by the third and fourth defendants, and they were all documented. The claimant further averred that he served the 2 years probation period, and having found that his work was satisfactory, his appointment was confirmed on the 7th of November 2017. The claimant also averred that the letters dated the 17th of June 2019 and the 6th of August 2019 were written by the third to the fourth defendant to the organs of the first defendant to correct the arbitrary stoppage of his salary and to restore his name on the payroll. The claimant urged the court to grant his reliefs and maintained that his claims are meritorious, competent, and not frivolous or an abuse of court process. At the plenary trial, the claimant testified in person by adopting a statement on oath as his evidence in chief and was thereafter cross-examined by the defendant's counsel. The defendant, in turn, fielded one Comfort Omaidu as the sole witness in support of their defense. She equally adopted her statement on oath, was also subjected to cross-examination by the claimant's counsel. At the close of plenary trial, parties filed and exchanged their written final addresses as prescribed by the provisions of Order 45 of the rules of this court. I shall state that pursuant to Order 62, Rule 10, Sub-Rule 5 of the rules of this court, parties agreed to adopt the previous proceedings and continue where the case had been stopped by the previous judge. Consequently, in the final address filed on the 27th Consequently, in the final address filed on the 27th of February 2024 by counsel for the defendant, Oyetunji Ojo Kaye Esquire, 2 issues were distilled as having arisen for determination in the suit, namely, 1 was the employment of the claimant wrongfully terminated by the defendant in view of the contract of employment between the parties and the conditions of service. 2, whether the claimants have adduced, it should be 1 claimant, so I put sick there, whether the claimant has adduced sufficient evidence to support his claim to entitle him to his relief sought. In the final address filed on the 18th of March 2024 by the claimant's counsel, A.O. Onoja Esquire, the 2 issues formulated as arising for determination are: 1, whether or not the claimant's employment was ever terminated, let alone the action of the claimant being any issue of wrongful termination by the defendant in view of the contracts of employment between the parties and conditions of service. 2, whether or not the claimant has adduced sufficient evidence to support his claim to entitle him to the relief sought. In other words, whether or not the claimant has previous case to be entitled to the judgment of this court in the light of the relief sought. I have painstakingly examined the totality of the pleadings filed by parties in contention the reliefs claimed, the totality of the admissible and relevant evidence adduced at the trial, and the totality of the written addresses and oral submissions of learned gentlemen for the two parties. My view is that issue 2, as formulated by the claimant's counsel, adequately covers the field of the dispute in the suit. As such, the court hereby adopts same in determining the suit. In adopting the issue, I shall make specific reference to the arguments as I deem necessary in the course of this judgment. The evidence on record is that the claimant was employed by the third defendant, that his appointment was confirmed, and that the employment relationship between the claimant and the third defendant is regulated by the terms and conditions of his employment. To further establish his employment status, the claimant's letter of offer of temporary appointment, letter of confirmation of appointment, and the revised scheme and condition of service were respectively tendered as Exhibit A, A2, and A5. By the statutory employment, the claimant is conferred with a legal status higher than an ordinary master-servant relationship. The effect of his employment status is that his employment is guided by the statute establishing the third defendant or the regulations made under it. For starters, I note that paragraph 4.15 to 4.18 of the defendant's counsel's address, an objection was raised on the admissibility of exhibits A6, A6B, and A6A. I should state right away that contrary to the argument of the defendant's counsel that the documents were rejected by the courts, it is shown in the records of the court of the 22nd of January 2024 that the documents were tendered by the subpoenaed witness, who was thereafter discharged. The defendant's counsel further argued that the said documents are inadmissible, being photocopies of public documents that required certification. As correctly submitted by defendant's counsel, the courts have consistently held that a public document must be certified as true copy of the original to be admissible. The certification serves as a guarantee by the public officer having custody of the original that the copy is a true reproduction of the original document. The case of Yabo and others versus Seidu and others, 2019, LPELR 48767 clarifies that while a certified true copy is admissible, a photocopy of a certified public document or even a photocopy of a certified true copy is generally inadmissible, notwithstanding that it was tendered by a subpoenaed witness. However, by virtue of Section 12 of the National Industrial Court Act 2006, this court may, in the interest of justice, depart from the Evidence Act. Therefore, these documents are admissible and are so hold. Now, the universal evidential principle is that the burden of proof, in any case, is on the person who desires a court to give judgment as to any legal right or liability dependent on the existence of facts which that person asserts or who will fail if no evidence were given on either side. See Section 133 of the Evidence Act 2011. I am also not unmindful that the claimant is claiming for declaratory reliefs. It is trite that declaratory reliefs are only granted as products of credible and cogent evidence proffered at the instance of the claimant. See Colonel Nicholas Anyaru retired versus Mandilas Limited, and the case of Ngweke versus Okerie, citations supplied. In the present case, I had undertaken a careful examination of the entire processes or pleadings filed by both parties. By my understanding of the facts as gleaned from the statement of facts, the claimant's case is that in breach of regulation governing the conditions of his service, the scheme of service, the defendants arbitrarily stopped his salaries and allowances in the month of April 2017 and to date, and that after series of demand, he was told sometime in 2019 that the stoppage may be an act of dismissal. In other words, the claimant's case borders on the breach of procedure for the stoppage of his salary or removal of his name for the payroll and the violation of his fundamental rights by the defendants. According to the claimants, before the arbitrary stoppage of his salary, he was never informed of any allegation of wrongdoing or invited to appear before a committee for investigation or served with any letter of purported dismissal from service of the third defendant, and the salary stoppage was without 3 months' notice or payment of salaries in lieu of notice. The claimant contends that the action of the defendant is a violation of his fundamental human rights as guaranteed by the Constitution of the Federal Republic of Nigeria as amended. In his arguments, counsel for the claimant referred to paragraph 4.3 of Exhibit A5 that states that payment of salary is a right which can only be withheld, suspended, or stopped as a result of a disciplinary action, that the arbitrary stoppage and wrongful removal of claimant's name from the payroll constitutes an infringement on the fundamental right to his salary. Counsel argued further that no evidence was placed before the court to prove that the claimant was tried for any disciplinary action and submitted that the arbitrary stoppage of the claimant's salary and wrongful removal of his name from the payroll from periods of April 2017 till date is contrary to Exhibit A5 and the statutes that established the third and fourth defendants. With reference to paragraph 4.3 sub A of Exhibit A5, counsel argued that the Kogi State Pay Parade has no power to arbitrarily stop or remove the name of the claimants from the payroll, that the defendants have not placed before the court the terms of reference of the said Kogi State Pay Parade to determine the extent of its power or whether it is empowered to stop the salary of the claimant without first determining the subsisting statutory employment regulated by Exhibit A5. Counsel submitted that it is settled law that a claimant succeeds on the strength of his case and not on the weakness of the defense, and that it is equally settled that a claimant is allowed to rely on or benefit from the weakness of the defense case that supports his case. The cases of Lokoja versus Ashiru, CPC versus INEC, and Onibandru versus Elejuda, where citations supplied were cited to support his propositions. Citing the provision of Section 167 sub D of the Evidence Act 2023 and the cases of Ateidu versus OB and the case of Associate Limited versus MRCAC, citation supplied, counsel submitted the defendants failed to place the terms of reference of Kogi State Pay Parade and urged the court to construe same against them. Counsel further argued that the arbitrary withdrawal of the claimant's salary by the defendants is unconstitutional as their action has infringed on his fundamental rights and have inflicted an untold hardship on him by their conduct. Finally, counsel finally urged the court to hold that the claimant has led credible evidence to entitle him to his claims. On the other hand, the defense advanced by the defendants is that the employment of the claimant's appointment, that the employment of the claimant was terminated by the defendants for non-compliance with the laid-down procedure, that the claimant had stopped working since 2017 and cannot be employed except through a regular and lawful process as provided for under relevant laws. The defendants contend that the claimant is is not entitled to the sum of 8,119,187 naira 75 kobo, or any sum at all, having not performed any duty since 2017. The argument of the defendants is that the process is further that the process of the claimant's appointment is regulated by paragraphs 2.1 and 2.2a sub A and C of Chapter 2 of Kogi State Polytechnic Revised Condition and Scheme of Service for Staff of Polytechnic 2017, that is Exhibit A, that as stated in paragraph 7 of Exhibit A, the conditions of employment of the claimant, the defendants are exonerated from any liability for terminating his appointment for irregularity in the process of his appointment. Counsel further argued that the screening exercise was conducted by the first defendants to verify the process of employment, staff lists, salaries, etc. of all institutions, ministries, and departments in the state, and in the circumstances affecting the terms of the employment was beyond the defendant's control. Now, in civil cases, as required by the law, the claimant has the initial burden to lead evidence to prove his assertion. But the burden of proof is not static. Once the claimant establishes a prima facie case, the burden of leading evidence in rebuttal shifts on the defendant and vice versa. In other words, the burden of proof may in the course of a case be shifted from one side to the other. See Section 136 of the Evidence Act supra. This provision of the Evidence Act has been considered by the courts in the plethora of authorities. See Onovo versus Mba, Ituama versus Akpeime, Ezemba versus Ibeneme and others, and another citation also applied. It is clear from the above authorities and the plethora of cases on burden of proof that in order to discover where the burden of proof lies in a civil case, the court has the duty to peruse the entire pleadings of both parties. In the present case, I had undertaken a careful examination of the entire processes and pleadings filed by both parties. The testimony of the claimant is that upon assumption of office, he produced the originals of his credentials for verification by the defendants, and his document and the documentation of the certificate was also conducted as required. See exhibits A1, A4, and A8. On the 4th of November 2015, the claimant's appointment was confirmed after his 2-year probationary period. See Exhibit A2 for the confirmation of appointment. The claimant has thus proved that he fulfilled the requirements for his appointment as stated in his letter of offer of appointment, and that his appointment was confirmed. The burden of leading evidence in rebuttal shifted on the defendants. However, the defendant failed to tender any documents to discharge the burden In rebuttal, the defendants merely alleged that the claimant's employment was not in compliance with the procedure as provided in paragraph 2.1 and 2.2 of Kogi State Polytechnic Revised Condition and Scheme of Service for Staff, but failed to prove their assertion. The defendant also failed to prove that the claimant and all other persons affected by the stoppage of their salaries were informed before the salary was stopped. It is important to note that, as stated in section B, paragraph 1.2 sub A of the revised condition of service, that is exhibit A5, the method of entry is by direct appointment of holders of good honors degree not below second class lower or equivalent qualification with NYSC discharge certificates. The claimants provided this certificate. The unequivocal finding of this court is that the claimant has essentially established a prima facie evidence by placing the exhibits to prove that he complied with the process of his appointment as stated in his letter of offer of employment. In other words, the process of appointment of the claimant was regular and as so hold. On the issue of termination of appointments of the claimant, placing reliance on paragraph 7 of the condition of service in exhibit A, counsel for the defendants argued that the termination of the claimant's appointment was automatic from the occurrence of the circumstances that prevent the Polytechnics, the third defendant, from carrying out the terms of the employment, which was beyond its reasonable control, and argued that the first defendant is exonerated from any liability that arise in terms of salaries, notice, or salary in lieu of notice, terminating the claimant's appointment. Having held supra that the claimant's appointment is regular, the defense of carrying out the terms of employment by circumstances beyond control does not avail the defendants, and as so further hold. As I earlier stated, the crux of the claimant's case is for payment of his salaries and allowances that were stopped and or removal of his name from the payroll by the defendants since April 2017. Counsel for the claimant submitted that by paragraph 4.3 of exhibit A5, payment of salary is a right and that it can only be withheld, suspended, or stopped as a result of a disciplinary action. In reaction, defendant's counsel submitted that the facts of the claimant's case do not support a violation of fundamental rights and that he has not proved any of the reliefs under section 33, 34, 35, 36, 43, and 44 of the Constitution of the Federal Republic of Nigeria or any other law. Counsel argued that the claimant's appointment has been terminated and he has not been working or engaged in any duty since 2017. He therefore urged the court to hold that the claimant is not entitled to the sum claimed or any sum at all. Now, the name of the claimant was still uncleared as at 6th of August 2019, uncleared for the payroll. Now the name of the claimant was still uncleared for the payroll as at 6th of August 2019 when the letters or memos written by registrar or secretary of the fourth defendant to the chairperson, Kogi State Staff Payroll, that is exhibits A6 and A6B were written. Thereafter, the Honorable Attorney General wrote exhibit A7 to the secretary to advise the state government to capture and restore the name of the claimant to the government payroll. Apparently, the claimant was not captured and his name restored, hence this case was instituted. The implication of the above evidence is that the claimant has not worked or been engaged in any duties since his salary was stopped in April 2017. Having not worked from April 2017 till date, is the claimant entitled to his claims for salaries, allowances, and reinstatements? My answer to this poser is an emphatic no. The settled law is that where there is an improper removal of an employee from employment protected by statute, the consequence is that the employee has not been removed from office. Or put differently, once dismissal or termination of employment is declared null and void, there is nothing legally standing in the way of the employee from having his or her job back with its attendance rights, benefits, and privileges. See the case of visitor of Imo State University and others versus Professor Okonkwo and others. And the case of Kwara Polytechnic, Ilorin versus Oyebanchi, citation supplied. Not being a case for termination or dismissal of appointment, the above stated principle is not applicable to the claimant. I also agree with the submission of the defendant's counsel that the facts presented by the claimant does not support his claim for violation of his fundamental human rights. However, I am not unmindful that by the conditions of service, the claimant's salary is a right which can be withheld, suspended, or stopped as a result of a disciplinary action. It is therefore my finding that the defendants, by their action of stopping the claimant's salary, are in breach of paragraph 4.3a of the conditions of service, that is, Exhibit A5. By stopping the claimant's salary and removing his name from the payroll, not being as a result of disciplinary action. Therefore, the claimant is entitled to his claim for damages for breach of the terms and conditions of his salary. Time and condition of his service, and I so hold. The principle guiding the assessment and award of damages as compensation have been set out in the plethora of decisions of the Apex Court. In G. Chintex Industry Limited versus Oceanic International Bank, 2005, Law Pavilion Electronic Law Reports 1293, Mustafa JSC, as it then was stated thus, I quote, the amount of damages to be paid to a person for breach of contract is the amount it will entail to put the person in the position he would have been if there had not been any breach, end of quote. Again, damages are meant to be full and adequate. However, as pointed out in British Transport Commission versus Goli, 1956, AC 185 at 208, The fullness and adequacy of damages awarded as compensation depends on the proven facts of each case and a just and fair assessment of the injury suffered and complained of. Having considered the principles of law above stated and taken into consideration of the facts of the deprivation of the claimant's job, salary, and removal of his name from the payroll since April 2017 as a result of the breach of the terms of his condition of service, a sum of 25 million naira is awarded in favor of the claimants. And as so hold. In the overall analysis, the court adjudges the claims of the claimants as meritorious in part for avoidance of doubt and abundance of clarity. Judgment is hereby entered in favor of the claimants in part against the defendants upon the set terms. 1, the defendants are hereby ordered to pay the claimant the sum of 25 million naira as damages. 2, it is hereby further ordered that the defendants shall pay to the claimant the sum set out in paragraph 1 above within 30 days. 3, 10% interest is awarded on the judgment sum from the date of judgment till final liquidation. Parties shall bear their respective costs. This is the judgment of the court.
I will pray God to give you more strength and give you justice.
My Lord, we are most grateful for this well-considered judgment. As we pray, the Lord to give you more strength and additional justice. Thank you, my Lord.
Thank you. This is a very difficult judgment because I did not start it. I couldn't.
My Lord, for the
You came under order 62, which compelled me to just take it over and just give judgment. Thank you. The judgment has been delivered. The judgment will be, the copy of the judgment should get to the division by next week, by God's grace. It will be transmitted with the files. Thank you. Okay, so we have the last case.
Case number NIC LKJ 10M 2025 between Mrs. R.U. Eluko and the Federal Medical Center, Lokoja, and 10 others. Parties absent, my lord.
No representation.
Claimant is present, please.
Claimant is present.
Claimant is present.
Claimant is present.
You represent the counsel to the claimant is present.
Did you say the claimant is present?
Claimant is absent, my lord.
Claimant is absent.
Appearances.
With due respect to the honorable court, my name is Dr. J.A.N. Eliko. appearing for the claimant.
May it please the court. I am
Yes.
Christiana Hassan, and I humbly announce my appearance for the first and seventh respondent.
What's the name?
Christiana Hassan. For the first and seventh respondents.
No legal representation for the other parties.
Yes, my lord.
Ruling. On the 29th of April, 2025, this honorable courts. No, this is not the case. I'm sorry. Ruling. The instant motion on notice was filed by the judgment's creditor applicant on the 19th of May 2025, praying this court for the principal relief set out as follows. 1, an order of this honorable court for committal against the respondents for willful disobedience. The judgment and order of this honorable court delivered by Honorable Justice O.O. Oyewumi on the 22nd of October 2020. 2, another of this honorable courts granting leave to the judgment creditor applicant to proceed against any of the principal officers of content law or the medical director, that is Dr. Olatunde O. Alabi, or any other responsible or highly placed officer of the contempt law for leave for committal to prison of the respondents for disobedience to the order of the court. The motion on notice is supported by 5-paragraph affidavit, and it is predicated on 9 grounds. The grounds are stated on the face of the ruling. I'll skip to save the time of the court. Annexed to the affidavit in support are Form 86, filed on the 19th of May, 2025, and the certificate of judgment. Also filed alongside with the motion is the written submission of applicant's counsel. To oppose the application, the respondents filed a 12-paragraph counter affidavit on the 10th of June 2025. Also filed with the counter affidavit is a written address of their counsel. A reply on points of law was filed by the judgment creditor on the 25th of October 2025. I note that 2 documents, offer of temporary appointment, that is Exhibit A, and letter of resignation of appointment, Exhibit B, were annexed to the reply on points of law. It is elementary that for documents to be admissible and given probative value, they must be properly exhibited to an affidavit without wasting time. The said Exhibits A and B that were attached directly to the reply on points of law without an accompanying affidavit is improper and is inadmissible, and are so hold. Now, the appropriate starting point in the instance application is to determine the preliminary issue raised by U.O. Onoja Esquire, counsel for the respondents. It is the argument of the counsel that the requirement of Section 115 sub 1 and 4 of the Evidence Act 2011 was not fulfilled by one Sunday Abu, the deponent of the affidavit in support of the applicant's motion. The further argument of counsel is that the said deponent is a litigation clerk. And the source of the deponent's information was not disclosed, citing the case of Meriami and another versus Gonidia Nari, 2025 Law Pavilion Electronic Law Report, 893. Counsel submitted that the evidence of the deponents is hearsay and inadmissible. In response, Chief J.A.N. Elupo Esquire, counsel for the applicants, argued that the deponents substantially complied with the requirements of Evidence Act by stating the facts that are within his knowledge, his personal knowledge. Counsel urged the court to discountenance the arguments of the counsel for the respondents and submitted that the courts have shifted away from technical approach in pursuit of substantial justice. I had taken a cursory examination of the affidavit in support of the instant application. The depositions of one Sunday Abu at paragraphs 1 to 4 thereof are reproduced as follows. I quote paragraph 1, that I am a litigation clerk in the chambers of Elupo and Co. of Julius Elupo Estate, Lokongoma, Lokoja. 2, that by virtue of my position aforesaid, I am conversant with the facts deposed therein. 3, that I have the authority of my employer and the applicant to depose to this affidavit. He further deposed that on the 2nd of April 2025, by 10 a.m., he was informed in the chambers of Elupo and Elupo at Julius Elupo Estate, Lokoja, and believed the facts as deposed in subparagraphs 4A to D of the supporting affidavit. The question that immediately comes to my mind, looking at this paragraph, is whether the applicant directly gave the information to the deponent, or if, as stated, the deponent's belief is in the chambers of Elupo and Co., as opposed to believing the applicant, or in believing in a named legal practitioner in the chambers of Elupo and Co. What seems more likely and credible is that the applicant briefed our counsel in chambers of Elupo and Co., and the information was given to the litigation clerk to depose in the affidavit. Hence, he deposed that he believes in the chambers of Elupo and Co. without stating the name of any legal practitioner in the chambers. This is more plausible, as it is rather strange that a client will directly brief or instruct a litigation clerk on a matter. Without a doubt, Section 1154 of Evidence Act permits a deponent to swear to facts derived from a third party in an affidavit insofar as it discloses the source of his information and verily believes the same to be correct, but such depositions can command very little weight or probative value as they constitute hearsay evidence, which is evidence given by a person who cannot vouch for the truth thereof. It is a piece of evidence which does not derive its value solely from the credit given to the witness himself, but rests in part on the veracity and competence of some other person. See the case of Lam & Co. Nigeria Limited versus Zakaria Okanga Properties Nigeria Limited, 2022, Law Pavilion Electronic Law Report at 59212, and Ibeto versus Ogu, 2022, Law Pavilion Electronic Law Report at 56803. In the instant case, the statements, information that the respondents have failed and refused to implement the judgment or order was relayed to the litigation clerk. The statement may have been given by the applicant to the legal practitioner in the chambers, and the facts were deposed as disclosed by the legal practitioner whose identity was undisclosed by the deponent. The fact is, the legal practitioner did not depose to the affidavit directly, did not depose to the affidavit directly. The said deponent did not conduct the case, and he failed to disclose the source of his information. The entire deposition does not derive its value solely from the credit given to the deponent himself, but rests in part on the veracity and competence of an undisclosed person, whoever his informant is. Since the substance of the supporting affidavit is based entirely on the facts deposed by the litigation clerk on information derived from undisclosed source, to the extent that the deposition contained in the said supporting affidavit seek to establish the truth of what was related to the deponent, they constitute inadmissible hearsay and cannot command such probative value or weight to form the basis of the discretion to be exercised in favor of the applicant. Depositions in affidavits must adhere strictly to the provisions outlined in Evidence Acts, and any deviation renders the deposition inadmissible. Regard is held to the celebrated case of McFoy versus USC 1961, 3 All English Law Reports at 1169. The legal principle that, I quote, you cannot place something on nothing and expect it to stand, end of quote, applies aptly in this case. The applicant's attempt to place reliance on deposition of a litigation clerk in a contempt proceedings is legally untenable and contrary to established principles of law. It is elementary law that contempt and committal proceedings is quasi-criminal proceeding and has the likelihood of affecting the liberty of a citizen. Against this backdrop, every procedural step must be followed strictly. See Okpobi versus Moniru, FCDA versus Koripamo Agri, citation supplied. The law is equally established that where a statute provides a particular method of performing a duty and on acts regulated by the statute, be it substantive or procedural, that method and no other methods must be adopted in the performance or conduct of the stated duty or act. See CCB Nigeria PLC versus Attorney General, Anambra State, and another citation supplied. A careful perusal of the processes filed by the applicant show that the applicant did not comply with the procedure prescribed in Order 9 Rules 13 sub 1 and 2 of the Judgment Enforcement Rules initiating the committal proceedings. Form 86, Notice of Consequence of Disobedience to Court Order, to Disobedience to Court Order, and the instant motion were both filed on the 19th of May, 2025. By the said Judgment Enforcement Rules, before filing the instant motion for committal on the judgment debtors, the applicant ought to have waited for at least 48 hours after the service of Form 86. It is equally noteworthy that there is no proof that the said process was personally served on Dr. Olatunde O. Alabi, the 7th respondent. It is clear that the judgment creditor did not comply with the procedure prescribed by the rules in the instant committal proceedings. And as a whole, on the whole, the instant application for committal of defendants is incompetent. It is hereby accordingly struck out. Parties, shall bear their respective costs.
As God
As the
pleases.
court pleases. We appreciate the industry of the court in this well-read judgment.
I'm grateful to the court. We shall come back to the house.
The court shall rise.